I'm Drew Stevenson, and this is a lecture about the scope of review or standards of judicial review under the Administrative Procedure Act in Section 706(2). Now, why does this matter? The Administrative Procedure Act creates judicial review and a right of judicial review for administrative agency actions. So government agencies or regulatory agencies that take an adverse action to an individual or a company or an industry can challenge that. They have a right of review in court, and part of the APA's framework for judicial review is to set out kind of levels of judicial scrutiny and versus deference for different types of cases that the judiciary will apply in that case. And this actually becomes super important in an administrative law or legislation and regulation class, because several of our big cases are about just either what one of these standards of review means or which of between two or three standard of review we're going to use. So Overton Park, Vermont Yankee, State Farm, even the Chevron doctrine, all somehow relate back to this. So we're going to go through them one by one. This isn't about a case. We're just going to look at a section of the Administrative Procedure Act. So here's the whole text of 706(2), and where it says that a reviewing court may set aside an agency action findings and conclusions found to be A, arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with law; B, contrary to constitutional right, power, privilege, or immunity; C, in excess of statutory jurisdiction, authority, limitations, or short of statutory right; D, without observance of procedure required by law; E, unsupported by substantial evidence, and I'll read the rest later; and F, unwarranted by the facts to the extent that the facts are subject to trial de novo by a reviewing court. So I'm going to walk through these one by one with you. So 706(2) A it ends up being the most important one: arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with the law. So if the court finds that an agency has made a decision in an arbitrary, capricious way, or abused its discretion, or somehow didn't act according to a law. So let's say there's a statute that says an agency has to act within a certain deadline, or has to certify something before they do it, and they skipped a step, that would be not in accordance with law. And they can hold, the court then can set aside the agency's action and findings and in such a case. So what do we mean here? In sort of common non-legal terminology, when we say something is arbitrary and capricious, we mean that there's no particular basis for it. So the ultimate arbitrary decision is flipping a coin, right? Or shaking a magic 8-ball. You have some random number generator, right? So random decision making is arbitrary. There's no basis for it. Flipping a coin, rolling dice, and so forth is arbitrary and capricious. Now, there are some areas of your life where decision theorists, that's an area of academia, would say you're actually better off making decisions using a random sortilege, like flipping a coin. Like, for example, when you're agonizing over which item to pick off of a menu or something like that. But when we talk about the government adopting a policy or approving the disbursement of a huge amount of millions of dollars of taxpayer funds, or imposing burdens on an industry, then we want to see that it wasn't arbitrary and capricious. And so here's another example. We don't want administrators who wake up and say, it's Tuesday, I say no to everything on Tuesday. It helps me get through the week, right? That would be arbitrary and capricious. So now when we get into court, what we end up, the courts want to say this, it turns into a show your work rule. In other words, we don't have any way of knowing that you weren't arbitrary and capricious, or that you didn't just abuse your discretion by deciding something out of thin air or whimsically, or maybe for some sinister reason, like because of your friendship with a certain person or a grudge that you're holding. That would also be an abuse of discretion. So in other words, we need you to paper the file, right? We need you to document that you had meetings, that you had reports after your meetings, that at the meeting, that you had other meetings where you discussed your reports, that you have this sort of workflow and process of decision making. It's a little bit like being required to show your work in math class, not just say how that you show that you had the correct answer. And from the standpoint of judicial review, you have to give them something to look at to see that you didn't make an arbitrary and capricious decision. Now, in real life, none of us think that an administrator is walking around flipping a coin, right? And that sounds like something a comic book character would do to make important government decisions, right? So we don't think that. We do worry sometimes that people in official capacities hold a grudge or are prejudiced or biased against certain groups or things like that and could abuse their discretion that way, or that there are certain people who are so haphazard and inconsistent in their decision making. We think that we are concerned that they're not making careful, deliberative decisions, considering alternatives, considering the consequences of their decisions, and so forth. So you're going to have to start to bulk up the file, so to speak, paper the file, create lots of documentation. Otherwise, please note, this is very important. Number one, that the agency, the court is not supposed to substitute its own policy decisions for the agency. So the court could say, actually, I disagree with this. I think the highway should have gone a little to the west, or I think we should have set the, if I were making the decision, let's say that you're the judge, you would have set the a level for a certain air pollution at a different amount, right? If you were in the agency, but you're not, you're a judge, and that person is in the agency, and that's part of the separation of powers. Congress delegated to the agency and the executive branch the authority to make that decision. So you don't, as a judge, you don't get to just say, I disagree, I would have done it this way. Instead, you have to say, I have to agree unless your decision was arbitrary, capricious, and so forth. And so the most that the court can do is ask you to prove or put on documentation and evidence that you went through this decision-making process. The second big point to remember here is that the Supreme Court and other courts have held that this is basically the default standard of review, right? So if none of the others apply, this applies, and this applies even if the other standards that we're going to talk about apply. In other words, in practice, if you are challenging an agency action, you can say it violates both the substantial evidence standard, that the agency lacked substantial evidence, and that it's arbitrary and capricious. You don't have to pick one or the other. The court can always do an arbitrary and capricious analysis in addition to reviewing the agency action under B through F. So let's keep going. Let's go to B. A reviewing court may hold unlawful and set aside an agency action or findings or conclusions found to be contrary to constitutional right, power, privilege, or immunity. So if the agency is singling out a particular religious group and either favoring them or disfavoring them, that violates the First Amendment. An agency interfering with your First Amendment rights might violate your constitutional rights. Agencies conducting in-person inspections without a search warrant could be contrary to some of your constitutional rights. When we talk about privileges and immunities, I want you to think about the state bar associations, which would count as an agency that in the past tried to have residency requirements for lawyers. In other words, they wouldn't give you a law license, even if you were qualified, unless you actually resided in the state. And the Supreme Court held that that violates the Privileges and Immunities Clause. So if an agency is trying to create an unconstitutional constitutional condition of a government benefit, then, or is using an unconstitutional basis for taking adverse actions against individuals, then that would violate B, and the court can set aside the agency's action. Let's move on. A reviewing court may hold unlawful and set aside an agency action, findings, and conclusions that are found to be C, in excess of statutory jurisdiction, authority, or limitations, or short of a statutory right. In other areas of law, we might call this the ultra vires doctrine, right? Like in corporate law, where you have directors who do things beyond the scope of their authority, right? Their legal authority. And essentially that's what we're talking about here. So you have, and this relates to the agency's enabling statute. You might remember that Congress will pass a statute and that basically authorizes an agency to promulgate regulations and adjudicate and or disperse benefits and so forth in a particular area, like the Environmental Protection Agency has statutes authorizing it to set air pollution standards. OSHA, which is about workplace safety, an agency covering workplace safety, is authorized by statute to set safety standards for workplaces and workers' protection and so forth. So imagine that the EPA decides to start regulating the stock market, right, instead of the environment. And well, that's not in their enabling statute, right? Now they are acting, they're winging it. They have gone outside their sort of pay grade, let's say, or their jurisdiction as circumscribed by their enabling statute. So one, if you are challenging an agency action in practice, one thing you can allege is the agency has gone beyond sort of ultra vires what they're empowered to do by Congress, and they have no power beyond what Congress gives them in their statutes. Now, don't get me wrong, these claims are hard to win because the enabling statutes that Congress passes are so open-ended, right? But this, the only boundaries on that are the non-delegation doctrine. But sometimes an agency will do something, let's say that you have a Department of Corrections or Department of Prisons or something like that, the Bureau of Prisons, that decides that they're going to start regulating gun trafficking or something like that, that doesn't have anything really to do with prisons, or it's so attenuated, it's really a stretch to see the connection. There have been a couple of times in our history in the past where you had an agency director who decided that they wanted to kind of expand their fiefdom or the reach and scope of their agency. So they started, let's say, pushing the envelope, like maybe the Federal Trade Commission, and regulating things that they had never regulated before to see if it would hold up in court. Okay, D. A reviewing court shall hold unlawful and set aside an agency action, findings, and conclusions found to be without observance of procedure required by law. You might remember we do some cases, there's some very famous cases like Goldberg v. Kelly and Matthews v. Eldridge about due process protections. And so the procedures required by law can be statutory, and that might remind you of, for example, the Florida East Coast Railway Company, or some of the things that require formal adjudication in the statute, or it could be judicial. So our fair hearings under the due process clause of the Constitution are essentially, the courts have said there's certain processes that we think that you need as protection for individuals when you're adjudicating. So this could be for regulating or for adjudicating that we're lacking the procedures that are required either by the courts or the statutes, and there are both. To give another example from a famous case, Cleveland Board of Education versus Loudermill, the statute spelled out hearing rights for government employees who were terminated. And again, if the statute has set out certain procedures, we're probably going to hold the government entity to that. Okay, E, this is one of our longer ones and more important ones. A reviewing court shall hold unlawful and set aside agency action, findings, and conclusions found to be unsupported by substantial evidence. in a case subject to sections 556 and 557 of this title, or otherwise reviewed on the record of an agency hearing provided by statute. Now, we call this a substantial evidence test, right? And part of the problem is we have a lot of cases where the court has to wrestle with whether to apply substantial evidence or arbitrary and capricious. Please remember, if substantial evidence applies, arbitrary and capricious also applies, but there's a whole bunch of cases, most cases, arbitrary and capricious will apply, but not substantial evidence. Note that there's a very clear express limitation. This applies to sections 556 and 557 of the Administrative Procedure Act. What's that about? That's about formal adjudication and formal rulemaking. So this will never apply. E will never apply to informal 553 notice and comment rulemaking by agencies. If the agency has promulgated a regulation through notice and comment rulemaking in the federal, by publishing in the Federal Register and having a public comment period, E never applies. We will not evaluate it on substantial evidence basis, unless for some reason they are required to make an on-the-record decision and review, or the statute says that they have to do formal rulemaking, in which case the APA says apply the same sections that apply to formal adjudication. Also note that E, the substantial evidence test, will never apply to informal adjudications like the type we had in Cleveland, Board of Ed v. Loudermill, and the other cases about government employees, Board of Regents v. Roth, Perry v. Sinderman. These are the famous cases where we're supposed to have a quick kind of hearing before we fire someone to give them a chance to tell their side of the story, or even Goldberg v. Kelly, which was an informal type of hearing. It does apply to Social Security disability hearings because the statute says that those will be decided on the record. So this will only apply to on-the-record decision-making, or that is formal adjudication and formal rulemaking, and never anywhere else. Okay, last one. The reviewing court shall hold unlawful and set aside agency action, findings, and conclusions found to be unwarranted by the facts, to the extent that the facts are subject to trial de novo by the reviewing court. Now, this is very rare. I couldn't point you to a case about this in administrative law where the court is using de novo review of the facts. Typically, under, for example, NLRB v. Hearst, the courts are supposed to defer to fact-finding by the agencies in the same way that an appellate court in the states would defer to a jury's fact-finding, but maybe not its legal holdings, unless the statute says that the courts have de novo review of certain agency actions, right? So if it's subject to de novo review, then we're going to go back and decide. The court then gets to really evaluate the merits. So please note, under 2F, this is de novo review, which is the most scrutiny, the least deferential. In other words, the court gets to start from scratch and just decide what they think the facts warrant under de novo review. We're starting from over again, de novo, and we don't have to give any deference to the agency. Again, very rare, but sometimes a statute will specify it or require it. Okay, there's a final clause added at the end of APA 706-2. In making the foregoing determinations, the court shall review the whole record or those parts of it cited by a party, and due account shall be taken of the rule of prejudicial error. So what are we saying here? We're talking about the whole record. So when the court is supposed to look at all of the documents that the agency put together, these are going to be file folders filling banker's boxes, sometimes filling by the truckload of the studies they conducted and the memos that they wrote and circulated internally, the meetings that they had, the reports that they have about the meetings that they had or what they reviewed at the meetings, and so forth. And all of this creates a large record. This is different from a sort of trial record, which is much more official, right? Where we take items into evidence formally and authenticate things and so forth. When we talk about a record of decision making, and the court really belabors this point in a few of the leading cases like Overland Park, the court wants to know what were the documents that were before the agency, and or other things, the other items, the maps, the photographs, the tables and graphs and scientific studies and publications and meeting minutes and so forth, all of those things that the agency had before it when it reached its decision and took its action. Okay, that concludes our lecture about standards of review under APA 706.